Hello, welcome. My name is Paul Lekas. I head up public policy at the Software and Information Industry Association, and I am pleased to welcome today two guests to our Tech and Conversation series. Chris Mohr, who is president of SIIA, and Tod Cohen, who is a partner at Steptoe Johnson. And our topic today is the Gonzalez and Tomlin cases, the recent cases that have been before the Supreme Court around Section 230 and platform content moderation. Chris and Tod, would you like to introduce yourselves a bit more?
Sure, and thanks, Paul, for hosting this version of Between Two Nerds. Before assuming this role, I was the general counsel of the association, and one of the really fun parts of the job was working on cases like this, which I had done quite a bit in private practice. And this area of platform liability has been, an area of both personal and professional interest from quite some time. So it was a lot of fun to work with you and Tod on getting this on both of these on both cases, but on Gonzalez in particular, where we filed our own brief. I'll turn the mic over to Tod.
Hi, I'm Tod Cohen, and partner at Steptoe Johnson, and thanks Paul and Chris for having the opportunity to talk about issues that I've been involved with for quite a long time. Before joining Steptoe earlier this year, I've been an in-house counsel with Twitter as well as eBay and PayPal and StubHub, and been dealing with a plethora of third-party liability issues all the way back to the passage of the Digital Millennium Copyright Act and the e-commerce directive in Europe, as well as the Communications Decency Act. So have been very involved in the development of this area of the law, and on behalf of the software manufacturers and information industry folks, it's been a pleasure to work with you all on this, on the amicus brief in this case, but in general on issues that are of great importance to the industry. So thanks for this.
Thank you, Tod. Thank you, Chris. The Supreme Court is considering two cases this term that go directly to the issue of Section 230. One of those cases, the Gonzalez case, the two of you submitted a brief on behalf of SIIA, and in the other case, Twitter versus Tamina, SIIA joined a brief as well. Can you tell me why are these cases significant?
Tod, you want to start with that?
Sure. The cases are significant because it's the first time the Supreme Court has even taken a case around Section 230 since its creation in 1996. So we have more than 25 years of its existence. I guess we're now in the 28th year of the Communications Decency Act, and the only remaining part of the Communications Decency Act, which was Section 230, which was an exclusion, electronic exclusion for third-party liability for online service providers. And there's some very specific language, and this is the first time the court has had a chance to explore the breadth of the statute and the breadth of the liability exemptions provided by Section 230.
Great. And what are the potential implications here? We don't yet know how the Supreme Court is going to rule on this case or the related case, the Tomlin case. Chris, what are the potential implications of a Supreme Court decision here?
Well, I think the implications are given by the path that these cases took to get here and the fact patterns that gave rise to them, which are very similar. There was, in each case, there was a terrorist attack and a series of allegations that a platform was involved in those attacks, but no allegations that the platform actually knew, no allegations that the perpetrators of these acts actually relied on either YouTube or Twitter. Instead, what they alleged was that the platforms are in general being used for this activity, and therefore they are liable. And there were two separate vehicles that were granted cert on. So in the one case, and it's a little bit odd, because Gonzalez in many respects is the more significant case, because there it's fairly straightforward. That case is about YouTube. There was propaganda on YouTube under 230 if that was not provided by YouTube, and so YouTube is not liable. If that is the way the case is read, it's over. If that is the way the case is not read, then you get into Tomney, which is a civil action under an anti-terrorism statute. And there the issue is whether or not the platform aided and abetted and knowingly provided substantial assistance. And the court spent about 3 hours of argument trying to figure that out. And that is just the tip of the iceberg, if the immunity is taken.
Go back and read section 230C1 states that no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider, meaning that online providers and services are not liable for the defamatory or otherwise harmful conduct of what their users post. And that's the crucial definition that is evaluated, and whether or not the actions that YouTube was taking in the Gonzalez case were to get out of the third-party content that was provided, but an examination of whether their displaying of it and, quote, recommending the ISIS content took it outside of the protection of Section 230.
And Todd, I'm glad that you went back to the statute, because that's where it all begins. And one of the, in fact, I think the most interesting piece of your brief is the focus on Section 230F4. And 230F4 addresses terms that I think are not commonly thought of in connection with 230, like pick and choose and filter. And can you explain why that matters really to the internet we have today, and why that was relevant to the argument that you built out in the brief?
I think the crucial part was that what is an interactive computer content provider or an interactive computer service? There's lots of different definitions around that.
And that's a statutory term in Section 230, right?
Yes, and Section F4 helps provide some of the context of what are the actions that an interactive computer service can take, or an access service provider can take, that allow for the protection that the liability exemption provides. So that it's not simply without Section F4, you'd have to determine, like, what are the steps that would be protected. And one of the things that access service providers can have protection for is selection, curation. It never uses the word recommendation, but it does allow for actions so that the display of the third-party content is possible, and that it is not simply a mere conduit and only just takes material and automatically places it online. Even though that it appears what the plaintiffs have argued is what the extent of the protection provided by 230 is, just mindless display, and that would be the extent of it, and that any type of curation would fall outside, because that would be actions taken by the interactive service provider. And Chris, you may have a better way to explain it a little more succinctly.
The thing that the petitioner tried to do was it tried to convince the court and say, hey, recommendations are different. And the government came in and said, yeah, recommendations are different, and these modern algorithms didn't exist back at the time that the CDA was enacted, and so therefore you shouldn't protect them. And that is, in our view, that was wrong for a whole bunch of reasons. The biggest one being among the biggest ones anyway, was because the problem of recovering data from a rapidly growing and an unstructured data lake has existed, at least it was well known in the literature around this stuff, at least since 1992, and pretty well explained. And recommendation and search, which the government tried to carve out, and which the plaintiffs, to some degree, plaintiffs, yeah, they were that too, also tried to carve out, are really, they're not two sides of the same coin. There is no coin. They're both the same. In other words, you can search a body of data for stuff that's relevant to you, which is the only way it's going to be useful. Either you can do it by typing in text, in which case you'll get answers that are probably going to be relevant to what you're looking for. Or you can spend time watching things and say, hey, I like this. And then by the same token, the algorithm is going to run a search for stuff that meets that same parameter. It's really it's no different. And more importantly, in the text of the statute, there is no difference. The statute doesn't draw any of those distinctions. So if you the way I looked at this was, if you keep it simple, it's an easy case. Some of the results, I think, from the bench were hard to swallow. But in terms of the way that there was a lot of, I heard a lot of commentary and one, now classic wisecrack about how these are not the 9 best experts on the internet, about how the justices didn't understand the technology. I think they did understand the technology and how it worked. I don't think they understood the legal test and how it was going to work, because it didn't make any sense in light of the way the statute is written. Now, obviously, we have a point of view, and this is witch casting to some degree, but that was the sense that I really came away from the argument with.
Yeah, I agree that I didn't agree with the 9. I mean, it was a clever remark about they're not 9 internet experts, but I did think that it was as well argued, and that the justices understood most of what was going on. This was not a black box. We don't know what this all is. And I thought Justice Robert, the Chief Justice's remarks, if he was the one who talked about the bookseller, that was really understanding what the plaintiffs wanted, and why that would be not within the reach of that it's still third-party content, and that a bookseller would therefore be responsible for every single book simply by placing the book in the book shop and putting it up on a display.
Looking at your brief, I mean, I think the focus on section 230F4 that expressly contemplates that internet platforms will essentially curate and evaluate through their own mechanisms information that is provided by outside parties, and provide that information to individuals, seems to be a pretty compelling case here. Very interested, given the environment right now. There's a lot of talk about regulating Section 230 and potentially curtailing Section 230 outside of the courts. And very interested to hear both of your perspectives.
230's been debated from the day it was passed, and it will be debated until far into the future, I believe. There has been one narrowing of 230 since it became law in 1996, which was the only change that we've seen, statutory change to it. Also a convincing reason why Congress's intent is being followed by the definition, not by the liability exemptions that have been granted by courts, because they haven't made any changes to it other than in the sex worker arena.
Legitimate that they look at a statute that has been around for so long and regulates so much of the information economy, but that's that's fine. That's just being a functioning legislature. There's a big difference between that and actually making changes to it, because when you watch the discussion that happens on the dais, they, even assuming that they understand the technology and what they're talking about, because their oral argument in congressional hearings can be quite different in terms of the level of knowledge. Not always, but sometimes can be different depending on the level of knowledge up there. And they, I think, had the same struggle. In other words, it's not so much, okay, well, we don't like this. Well, how do we fix it? And then every time they come up with some angle to think, some harm that they would like to redress, there are immediately overbreath problems when they start to talk about them, and tons of unintended consequences, which is why, it's probably not that great an idea.
Well, I think you saw that most clearly with Justice Thomas, who's been had dropped 3 opinions prior in dissents and in failure to grant cert in a few cases, where he talked about trying to limit Section 230. But then when the oral argument came, it was very hard for him to articulate, and was most pressing on the plaintiff to set a standard of what would be outside of 230.
And I think that, when you step back and look at the context of this argument and what the petitioners were doing in terms of the kinds of the other cases that the court has both taken and decided, their theories were reminiscent of the types of kind of touch fouls that the court really didn't like in Spokio and TransUnion in cases where they're trying to limit standing. And the idea that, okay, well, there was a substantial portion of, for example, the petitioner's reply brief that dealt with the idea of thumbnails. And because you create a thumbnail of a video, aha, we've got you, because that's no longer, third-party content. That's now become YouTube's content. And, you are now on the hook for all of it. That's very similar to the kind of thing that says, you forgot to send me this notice that nobody read, therefore you owe me $1,500 in statutory damages. And by the way, I brought along 3 million of my friends. Where's your checkbook? They are not hospitable to that kind of litigation most of the time. And I think that type of reading is inevitable. And it's not, I was on a panel at AU, and the thing about this is that sometimes you say, oh God, I wish I'd included that. I thought to include that. And one of the things was, that doctrine exists under federal law. In other words, there's got to be a real harm for you to have a case, particularly in a privacy dispute or an informational dispute. Those standing requirements don't exist in the states. And so you get rid of the statute, and not only are you going to have a whole bunch of laws based on inchoate injury that you're going to have to defend against, you will have the specter of statutory damage multipliers in a lot of these states. Illinois is an excellent example. And Michigan is another one. They amended the offending statute a few years ago, but they had a similar cause of action where it was just, it was open season for the class action bar. That's what happens if they get it wrong.
I forecast, and for what it's worth, I think that Section 230 will stand in the YouTube. The dismissal will be affirmed from both the district court as well as the Ninth Circuit. But I think that the court and the majority opinion, definitely in potentially a dissent from Justice Jackson, who appears to be very close to the administration's position on the recommendations and the actions taken by that, and is reading it as only as a Good Samaritan statute, and therefore that's all that gets protected. I think she's going to potentially write a dissent, but that the general viewpoint will be that recommendations are part and parcel of what interactive service providers do, and that therefore they are going to be protected in this, and that the court will then say that there's limits around negligent design and actions by interactive service providers directly that will fall outside. So there'll be a lot of dicta, I believe, around what the limit is. They'll read in the F4 and then they'll say, but anything beyond that is going to be outside.
We know we have at least one vote because Justice Gorsuch was asking questions that were right out of our songbook. And so if he can bring 7 other people along, that's a good day for us. I think, you know, to me, and he very well could, with the kinds of limits that Todd was talking about, whether they draw it around negligent design, whether they draw it around the concept of adoption. In other words, there was some discussion of that. You know, if you as a platform put yourself in a position where you adopt certain statements as your own, you then become responsible for them. But ordinarily you would not be under the terms of the statute. All of that is very much up in the air. The tougher one for me is I can't quite figure out what they do with Tomney, because if Gonzalez comes out the way that it seems like it's going to, there's no reason for that case to be there. Because it never should have been, that petition never should have been granted. So maybe that one goes back with a remand to dismiss, or remand to deal with in light of the decision in Gonzalez. I don't know.
I would guess that. I would guess that, because to reach out to discuss the Anti-Terrorism Act directly doesn't need to be done.
Yeah, fair enough.
Great, thank you. And it took them 3 hours. It could probably take us a couple of days to talk through all of the issues here, but this has been an illuminating conversation. And very much thank you, Tod Cohen and Chris Mohr, for joining this conversation and talking about the cases before the Supreme Court on the important issues of Section 230 and content moderation. And thank you all for listening to this installment of SIA's Tech and Conversation series.